We're on the record in Stevens versus Stevens.
Good morning, Your Honor. David Delaney appearing on behalf of Matt Stevens. He is present in my office.
Good morning, Judge. Again, Elliot Blumberg on behalf of Joy Stevens.
Okay, we're on the record today for a show cause hearing on enforcement of a prior order of the court. I did review your motion for show cause, Mr. Blumberg, and Mr. Delaney, I did get your response and attachment, so I reviewed that. So Mr. Blumberg, from your standpoint, where are we at as we sit here today?
I wish I knew, Your Honor. I received from Mr. Delaney this morning two documents that suggest that, one, he's listed the property for sale. Finally, the court ordered him to do that within 30 days of the last court proceeding, which he didn't do. We were led to believe that there was some refinancing going on. That have not received any documentation confirming that. I think it's important because right after the court ordered that the property be listed for sale, we provided Mr. Delaney with the potential of 3 different realtors that would handle that. Mr. Delaney rejected all 3 of those and just sort of unilaterally found somebody who has 2 listings in her entire office. So I don't know where we're at. Again, Mr. Delaney sent me some correspondence this morning that shows that somebody else is buying this property and there's been an approval of financing. So I would defer to Mr. Delaney to explain to the court why on the day before the show cause hearing, we've received all this information.
All right, thank you. Mr. Delaney?
Going back to the June 5th order, the property could not be listed for 2 reasons. One, there was a lien recorded against the property, which the defendant, Joy Stevens, generated. That was resolved. Number 2, there was a power of attorney. The amended statutes related to POAs require that it be notarized. So the listing agent again rejected listing the property without a properly notarized power of attorney. All those 2 documents were resolved not until August 4th. So that's 2 months that the property could not be listed and the property could not be refinanced. During the course of that, I did indicate to Mr. Blumberg, and we both attached the emails, that we would, in lieu of listing it, refinance the property. I know that required a signed stipulation to be filed with the court. I agree, we did not do that, but we did have it in writing via emails. When those 2 issues were resolved, lien and power of attorney, my client had to re-begin his financing options, which had been plodding along because the bank is uncomfortable with the fact that the defendant's incarcerated. The POA came in late, notarized, the lien's resolved. So the case, because of that, hasn't progressed as it should have. But we have today a proposed listing agreement, which Mr. Blumberg needs to sign. I know it came in last night. That's when I got it. Number 2, we have a signed offer to purchase the property, which will resolve the debt to the defendant and pay off the first mortgage. And 3, the buyer has pre-approved financing. I sent a copy of that to Mr. Blumberg this morning. That's when I got it. So I think we've resolved the issue in this case, Judge. I recognize the court signed in order to show cause. In the event that that remains compelling, my client only got served with that 14 days ago. It's a criminal contempt, and I would need time to prepare a defense to that and ask the court to set that over for a period of time to allow me to prepare whatever the court believes is reasonable. And it's criminal contempt. So I have to take that seriously with my client. But back to resolving the problem, Judge, those are on Mr. Blumberg's desk. He signs those documents, we'll proceed to closing as quickly as possible. But even if we don't, the property will be listed. I don't understand the negative comment about the broker, the number of listings and things like that. It'll be listed together with pursuing a closing. Thank you.
All right, Mr. Blumberg.
It's astounding to me, Judge, that somehow the delay is attributed to my client and myself. There was your Honor is aware of the fact, even if there's a lien on the property, that doesn't stop the property from being listed for sale. Liens are generally cleared up at the time of closing. But when I was notified of it, within 3 days, the state of Michigan lien was resolved. We had the power of attorney. Mr. Delaney pointed out again, mysteriously to me, that somehow the lender was going to require it to be notarized. So we got it notarized. These are all delays of a minimal nature. This case has been pending for 7 months since the plaintiff was ordered to pay. And here we are on the day before the show cause hearing, or the day of, we all of a sudden mysteriously, now there's financing available. I hope it's true. I wouldn't be surprised if it isn't, but if it's true, let's get the thing closed and my client paid. I think it is appropriate, though, for Mr. Stevens to be responsible for more attorney's fees that were wrongfully incurred because of his failure to comply with the court order. I don't want him necessarily thrown in jail. I want my client to get the money that she was ordered to receive. That's the bottom line.
Okay. All right. So, this has been pending a long time. I know that both of you probably are anxious to get this resolved. I know I certainly would love to stop seeing it show up on my docket. This needs to be done one way or the other. It's languished for way longer than it needs to. So based on what sounds like, and I'm going to accept Mr. Delaney's representation to the record here today, that there's movement imminent. I'm going to set this for, I'm going to hold any finding of contempt in abeyance for 30 days. The court will set this for another hearing 30 days from now. Mr. Delaney, there needs to be like concrete, real action on this case over the next 30 days. Otherwise, the court's going to consider sanctions. But when we're back here, your client's going to need to come with some, whether that's signed documentation, whether the deal's done, whatever it is, but there needs to be some positive, concrete, verifiable movement on this case and this real estate within the next 30 days. So that's how we'll proceed. The court will set it for a day. We'll send out notice of the date and time of that hearing. Mr. Delaney, to the extent that we can have documentation, in advance of that hearing, perhaps we wouldn't even need it, and which I think all of us would be overjoyed to hear. So to the extent that you can get that to Mr. Blumberg, and then maybe we don't even have to have that hearing, but otherwise, if we do have it, I'm going to need something concrete, verifiable as to the progress over the past 30 days. That's all I have for today. Thank you. All parties are free to disconnect at this time.
Just before, hold on, before we go, I just want to make sure I understand. Is the property being listed for sale, or is there an accepted offer? Because my client needs to sign through me, the power of attorney, to accept the offer. So I don't know which is happening.
I can answer. I can't list it until Mr. Blumberg signs the listing agreement. My client has signed the listing. Secondly, the purchase agreement, my client has signed that. So Mr. Blumberg would need to sign that also. So if you sign the listing and the purchase, we're on our way.
Okay, so if I may ask, this offer to purchase, is it through the real estate company?
Yes.
Okay, all right. And you've approved whatever percentage of commission she's receiving?
Yes.
Okay, I'll be happy to look at those and sign them. Thank you.
Thank you. Thank you, Judge.
All right, thank you.